Hey guys, it appears that Evan Rachel Wood and Illma Gore have filed motions at the state court level in California for reimbursement of attorney's fees and expenses related to the special motion to strike. In other words, the anti-SLAPP motion that they won against Manson. Of course, Manson is lodging an appeal of that, but I thought it would be interesting to go over this. There's going to be a lot of documents on this. I'm only going to look at one set, short set, but there are hundreds of pages, maybe 300 or 400 pages involved. We're not doing that. We're only going to do one. And I think that's going to set the tone for you, and you'll see how this is going to go. This is Evan Rachel Wood's motion for attorney's fees and cost, and not all the documents that support it, and also not Illma Gore's. All right, let's dig into it here. Let me get it to larger to where you can see it as I go through it. All right, so I omitted the cover page, and she says that on January 26th, 2024, she wants to set this up for hearing, asking the court to compel Marilyn Manson to reimburse her $346,470 in attorney's fees, $9,193.67 in cost incurred with a successful special motion to strike. She wants $22,050 for preparing this motion and $10,100 in attorney's fees that she anticipates will be incurred making a reply brief, because she thinks Manson will contest this, which he can do. He can contest the rate of the fees, the scope of the work, things like that, and the court makes the decision. So she's making this motion on the basis that a prevailing defendant on a special motion to strike is entitled to recover attorney's fees and costs. And that's clearly true. And that the court entered an order granting her motion to strike. And in the order said a prevailing defendant on a special motion to strike shall be entitled to recover his or her attorney's fees and costs. And here she says she's the prevailing party, or rather the defendants are, which they were. So they may file these noticed motions. Blah, blah, blah. As I said, we're not going to look at all of it, but we'll look at this actual notice of motion and motion. And the summary is introduction. You just got introduced to it. She's entitled to it, she says, and it's so reasonable. The time spent was reasonable. The rates are fully reasonable. The costs are reasonable. Everything is reasonable. Now, Manson may not agree with that. These guys haven't agreed on much in this case. Here's lots of cases that she cites. Let's get into it. All right. She calls it a retaliatory lawsuit against her because she refused to remain silent about the abuse she suffered at his hands, talking about Manson. Worse, even in an unsuccessful attempt to discredit her, he timed his lawsuit to coincide with the release of the two-part HBO documentary, Phoenix Rising, that chronicles her experience as a domestic violence survivor and an activist. So they're coming out guns blazing on this, huh, right? And what? They should. It's their lawyers talking. She says that his lawsuit is all bark and no bite. And he has, and they're putting this in italics, and make sure you get the picture, no evidence to substantiate his meritless claims, many of which arose from her protected activity, they say, the criminal investigation of Manson, they say, and promoting legislative reforms. But nevertheless, she gave Manson a chance to avoid this anti-SLAPP motion and a resulting fee award entirely, even though they didn't have an obligation to do it. She explained the basis of her anti-SLAPP motion and offered him a chance to amend or dismiss his complaint before it was filed. Interesting. And I know from the judge's prior article, she likes that kind of thing. And if they did do that the way they say, and it didn't get a positive response, it's not going to help Manson in contesting these fees. He not only refused to relent, he consistently multiplied and delayed the proceedings. He filed a largely unsuccessful motion for anti-SLAPP discovery, 3 ex parte applications, 9 declarations, dozens of exhibits, many unauthenticated and inadmissible. As a result of his conduct, they say, it took more than a year to litigate her anti-SLAPP motion. Well, okay, and part of that's true, but part of it just takes a long time, right? It's going to be expensive no matter who's doing it, but they're going to put it on Manson, of course. As the prevailing party, she's entitled to recover all of those fees and costs from Manson. So we already went over the money, and we won't repeat that. But nearly $400,000. Now, Gore has her own motion, not going over tonight, But, that's going to be up there too. So this is a lot of money. And in theory, if Manson doesn't win his appeal, not only does he not have that part of his case anymore, but he's got to be stroking a check to these people. And if he loses the appeal, that number is going to likely grow. So not good news for him. But anybody who saw this should know it's coming, right? If you're watching this case, nothing in this is a surprise, and not the number either. I mean, I said it was going to be high, and it's up there, but that's the nature of this situation. All right. She says it's reasonable based on the time required to litigate her successful motion. And, I'll let Manson respond to that. I'm not going to do it because I'm not going to dig into the 300 pages or whatever they have supporting all this stuff tonight. But of course they pinned it on him, and she's entitled to this fee reward, mandatory award of attorney's fees and costs. That's true. And they note that the court granted defendants anti-slight motions and struck his claim for intentional infliction of emotional distress based on allegations regarding the purportedly fabricated letter. The FBI letter claim is what they're calling it. That's FBI letter claim. I like that. That's something both sides could call it. Plaintiff's IIED claim based on his allegations regarding the film Groupie claim, and the IIED claim based on purported recruitment of other women. The recruitment claim and defamation per se, all stricken because defendants demonstrated that the claims arose from protected activity, and plaintiff failed to meet his burden to demonstrate that his claims even have minimal merit. The court ruled on May 9th, 2023, that defendants, that's Wood and Gore, are the prevailing parties on their respective motions, so they may file noticed motions for attorney's fees and costs. Accordingly, the only issue before the court is the amount of fees and costs awarded. And here they say it's totally reasonable. You're allowed to get what you need to extricate yourself from a baseless lawsuit. They cite a case that says that, and it shall be construed broadly. And an attorney fee award should ordinarily include compensation for all the hours reasonably spent, including those related solely to the fee. Just settled a case recently on a smaller number than this, but that's because we all worked it out together. And unfortunately, these guys didn't. In determining an attorney's fee award, courts typically use a lodestar approach. The number of hours reasonably expended multiplied by the reasonable hourly rate. And in figuring out what fee request is reasonable, they may and should consider the nature of the litigation, difficulty, the amount involved, skill required, skill employed in handling the litigation, attention given, success for the attorney's efforts, etc. But keep in mind, if they succeed here and Manson pays this, not only have they won on their motions to strike, but Wood and Gore don't even have to pay for it because Manson will be paying that in addition to his own lawyer. So again, this is behind the eight ball when you lose these motions to strike, is where Manson is on this suit right now. That's, he's got his appeal filed, of course. And if he's successful in that, this could go away. We've already talked about that. Okay, let's see. You got to assess it on its own merits. I am trying to scroll this so you can see it, hopefully. Using this rubric, it's not unusual for California courts to issue and affirm six-figure fee awards to reimburse defendants for costs and fees incurred in successfully prosecuting any slight motion. And they cite some cases, $200,000 plus $36,000, this, that, and the other. So yeah, I mean, it's expensive. There's a big dog there, another $166,000, $76,000, yada yada. Federal courts also give out big dollar fee awards to the people who are successful here, they say. $300,000. Here's one for $800,000. Now, how reasonable is less than $400,000 when you look at that? So, okay. And there's a lot of those. And they're making their point that the numbers they're quoting are not anything out of the ordinary as they see it. Let's see. I'm looking for the flowery language here that I enjoy in these motions rather than just the repeating of the numbers, although I know they got to do that. All right. So the time spent was reasonable. This was no ordinary anti-slight motion. She filed her motion on April 28, 2022. Gore shortly thereafter. They were litigated for more than a year before the court finally granted this thing on May 9th, 2024. And she blames Manson for multiplying the proceedings and increasing the fees and cost. As she mentioned before, all these things that she says he did, lots of exhibits he shouldn't have filed, didn't need to, requesting discovery, things like that. All the actual anti-SLAPP stuff itself, reply briefs, joint statements about the evidence, all the things they had to do in the case. This case has been heavily litigated for something that's purportedly on a motion to strike or kind of a motion to dismiss posture. So it's a lot for that. It's been a lot to look at. And now here comes the bill at the end of dinner. Who wants to pick up the check? All right. They prepared and appeared for one deposition, 6 hearings before this court. And that's a lot. They attacked 4 separate claims of the ones we already mentioned. I'm going to keep it moving here. So she wants fees for work performed in connection with researching, drafting, and revising anti-SLAPP motion, requests for judicial notice, and other supporting papers, including declarations and evidence, 2 ex parte applications to continue the anti-SLAPP hearing, attending the ex parte hearings, researching and drafting, all these things. And I will scroll them slowly so you can look at them, because we finally get to a chart, which would be nice to get to eventually. Here's the time spent on the task is detailed below. So the partner has got 7.3 hours up in there, and another partner 83.3. And here's some more all partner stuff here. And it's all partners. And Sean Hawley's not showing up as much on here as I thought, because I think she did some good work on this case. Maybe she's a little bit later in this. Look at all these hours. Senior associate, paralegal. And here's all these activities. Paralegals, partners, associates, people in the firm working on things. These are all normal kind of stuff. I kind of want to see what the rates are. We'll see if it gets there before I have to go. All right. So they say they spent collectively about 500 hours on this thing. And the court should defer to the winning lawyer's professional judgment as to how much time he's required to spend on the case, not the loser who doesn't want to pay, of course. And if you want to deny it, the time claim must obviously and convincingly be excessive under the circumstances. Most of the work was performed by the attorney with the lowest billing rate on the case team. Say they were being as efficient as they possibly could. And Miss Holly spent 0.3 hours total on the matter. And that's surprising to me, because I thought I saw her name on several things. So again, whoever did do the work on this case did do a great job for Wood. That's for sure. Said that before, and I will repeat it here. And I'm just glad I don't have to pay for it. I just only had to read it. Let's see. Here's more talking about that. That's particularly reasonable given that the frivolous lawsuit assails Wood's reputation and character and appears to be motivated and calculated to cause embarrassment while seeking to extract compensatory damages, punitive damages. So while he's running this crusade against her, she's putting the lightest weight in terms of fee-based stuff that she can on the case, that her firm is being very fiscally responsible. But whether the person's the cheapest or not, it's more important than whether they're effective or not, and they have been effective. All right. In a similar case, they got more money. 2 months before the court granted Wood's motion, the Honorable Curtis A. Kim awarded $493,000 in fees in connection with his anti-SLAPP motion filed by Phoebe Bridger's defamation lawsuit. Again, they noted that they weren't required to do it, but they did meet and confer with plaintiff's counsel prior to filing this motion to see if they could resolve or narrow the issues. That looks good for them. Sounds good for them. The rates charged are reasonable. Prepare to be outraged if you're a normal person. Let's see what they're charging for this and who the lowest priced person is. You look at the rate prevailing in the community for similar work. Court may also consider an attorney's actual billing rate. $850 an hour, non-contingent basis, blah, blah, blah. They haven't put it in here yet. And they talk about their degrees and experience, which is normal because you got to show, well, why can you charge that much? And then the Daily Journal and the award for this, an article about that. It's all very fair. So Mr. Kump charged $850 per hour in 2022 and bumped that to $900 per hour in 2023. It's extremely reasonable given his experience and skill and the rates being charged by other lawyers in the market. Sean Hawley is top 100 power lawyers, etc. $800 an hour. Here comes Rising Star. Catherine, up and coming, top 40 under 40. Entertainment IP litigation, lawyer of the year. A mere $625, bumped slightly and very modestly to $650 per hour in 2023. Man, I'm telling you, these days they can be quite reasonable. So it's crazy, but true. Then we got a senior associate up in here working at $525 an hour. And so they're a top-tier litigation boutique in California. They're recognized for their expertise in complex litigation. And they say, guess what? We're not charging anything more than his lawyers do. What's up? That's a good one. That's a good one to throw at him. They got Howard King's declaration in connection with a motion for attorney's fees in another matter, stating that his hourly rate 3 years ago in 2020, italics, was $825 an hour. So how's he going to argue against the numbers they're quoting when he's quoting that much or more? And they won this case. All right, so that's fair, I think. And they got a bunch of stuff in there about that. So, as I've said before, I think both sides have done as good as you can in a case like this. They fought hard, but Wood's lawyers did a really good job over this FBI letter claim thing, I think. And that was it's been kind of a crux point for this case, and it's going to be important for Manson on appeal, which he's certainly not giving up. He's going to make his arguments to the Court of Appeals, which, again, if he were successful there, would moot this. But I've already said what I think about the odds on that. Let's keep it rolling. The quality of the representation. Yeah, here we go. You can blow your own horn a little bit. You're trying to get a bill paid. Her counsel achieved a dismissal of all 4 claims that were subject to her motion. So she just didn't win a little bit. She won a lot, she says. She didn't overreach and seek to strike his other claims, swatting, impersonation, and hacking, even though she says they're meritless, because they don't qualify for any slap. So she's saying she kept it all within the scope of what was appropriate for a motion like this. Didn't waste anybody's time. All right. I've got some cost up in there, and that's, filing fees, online research, messenger services. Nice. Court reporting. All right. So that's it. So we see here Evan Rachel Wood asking for just under $400,000 for her motion to strike. She'd like Manson to make that out into check. That'd be great. And then Gore has a similar motion filed. I'm not going to look at it tonight. They both have supporting documentation that's hundreds of pages. I assume has activities and biographies and things like that in it. Normally what you see for something like this. So I figured this would come. I didn't know it would come at this point, and based on the procedural posture of the case, but yet it has. And I thought people would want to see it. And so that's that. Thanks. Bye.